Good morning. This is Anthony Davis. I am one of Christopher Nudo's attorneys. I do estate planning, though our firm and my practice is a little bit more extensive as well. So we also do residential and commercial real estate and estate planning. Probate in addition to estate planning. But today, what we're looking to do is to just have a short little video where we kind of go over some common action items that are important to a lot of our clients. And here, what we're going to be doing is discussing kind of how we can set our parents up for success as they age. This, of course, involves estate planning, but it can be a little bit more expansive than that. So we're going to go and untangle that in this short little video. I've got 10 action items up on the screen here, and we're just going to move through all of these at a pretty brisk pace. Our first one is the most important, and that's going to be just initiating the estate planning conversation. So I always tell my clients to remember that, well, all that we're really doing in estate planning is preparing contracts and documents, but we don't want to forget the human experience. And we got to remember that this is a pretty tough topic. So occasionally I'll have kids that'll come on in. They'll want to bring their parents on in, and they're wanting to move very aggressively on the estate plan, but mom and dad might not be. And we need to make sure before we go and we do anything that mom and dad are kind of on the same page. So that's very important. This can take a long time for them to come around sometimes. But what we really want to do is we want to set the stage. We want to plant the seed. And the way that we want to do that, typically what I find is most successful is just working with them to set a goal that is something that they are open to and interested in. So most of the time, this is going to be just gently sitting down with them and, mom and dad, you've been great parents. You've done a lot for us. Now what we're looking to do, we've got some concerns about how we can take care of you as you age, and we want to make sure that we've got the proper legal documents in place. And we're hoping that you would be willing to come and speak with an attorney at some point, whenever you feel ready for it, and get those documents in order, because we want to be able to work with you to take care of you. We want to make it, I always suggest making it as positive a conversation as you can. It really does take a certain amount of courage, I feel, to even discuss estate planning at all. And we absolutely never want to be pushy with them. We always want to give them the freedom to choose when and if they're going to meet with that attorney and ultimately do their estate plan. The next thing down here is we've got our wills versus trusts, probably the most common question that I get asked. I'm going to be real brief here. Wills versus trusts, you go online and you'll get these one size fits all cookie cutter solutions. It really depends on the client. It really does. In the land of logic, I think a lot of times the trust is going to be the superior instrument. But typically the analysis is actually a little bit more complicated, and we have to take into account the personalities of our different fiduciaries, and most importantly, of course, the goals of the client. And while I typically will lean towards trusts and think that often it's the superior instrument, it isn't always. And it's really is good if we can get that personalized one-on-one consult to kind of figure out what is going to be best for the client. To kind of put it in real simple language, though, what a trust is just a big contract. And what a will is it's an instrument that goes with this thing called the probate court. So really it comes down to a question of if we want to use contract law to transfer the estate to the next generation, or if we want to use testamentary law, the court system, to transfer the estate to the next generation. Number 3 and 4 down here, we've got our powers of attorney. POAs, really, really important instruments, particularly in regards to elder care. I'm going to kind of treat both of these as the same item. With a power of attorney, what we're doing is they're living documents, so they only function while we're alive. They're only going to function while mom and dad are alive. After they pass away, they cease to do anything. With a power of attorney, what we're doing is we're designating an agent, and that agent has the authority to step into our shoes and make decisions for us when we're unable to. With our healthcare power of attorney, which is one document, our healthcare power of attorney is giving our agent the ability to make healthcare decisions for us. So, whether a surgery is appropriate or perhaps a certain medication, hospital treatment, that kind of thing. Whereas a power of attorney for finance, which is a distinct and separate document on its own, sometimes these are referred to as powers of attorney for property. These are giving access to finances. So to kind of bring this down into the real world, if mom and dad designate you as being their power of attorney for finance, typically this means that you would have broad access to their accounts so that you could move money around and pay for various expenses that they have that are now more difficult for them to take care of. Whereas the power of attorney for healthcare, what they've done is they would have given you the authority to make those tough healthcare related decisions for them. Number 5 down here, we've got our beneficiary designations. So super, super important. We don't want to forget this. So with our bank accounts, our retirement accounts, and with our insurance, we can set beneficiary designations on those accounts. So what this means is that upon our loved one's passing, instead of that account going through a long, slow, cumbersome probate process, going through the courts, that account can pay out directly to those designated beneficiaries. So let's say that we've got a savings account with $20,000 in it. And let's say that mom has 2 kids. She's the surviving spouse. If she wants to have that account pay out to the 2 kids outside of probate, what she's going to do is she's going to designate the 2 kids as beneficiaries on the account. Upon her passing, one of the 2 kids can go to that bank with a copy of the death certificate, and that account will pay out directly to them as designated on the beneficiary form in an equal share. So that's how that works. So good goal to set is you want to make sure that mom and dad have their beneficiary forms in order on all of their accounts. With your average American estate, you can typically have most of the estate distributed by beneficiary forms, and then we're giving most of our thought to how it is that we would transfer any real estate that they have. Oftentimes we'll use either a trust or will to do that. So something very important to keep in mind and keep an eye on. Another thing that we can do with a trust or will is that we can set guardianship designations on it. So ideally with our estate plan, we're not going to be relying on having a court-appointed guardian come in to take care of mom and dad. Typically what we're going to be hoping to do is to have either, if we have a trust, have the trust on its own grant authority over the trust assets. And then for everything else, use a power of attorney for finance or power of attorney for property. So when mom or dad get sick, we have the ability to access their assets and make the appropriate decisions regarding them, maintain that estate, and maintain those finances. But it is prudent in a document to set potential guardians, and you can certainly do that. So if mom and dad get sick and they've got you designated as their preferred guardian, then that means that if a court appointee has to be designated, they're saying that their preference is that it would be you. And a court-appointed guardian has pretty extensive powers. Our next thing that we've got down here is just knowing a little bit about that probate process. So again, probate is this big court system. It's what an estate will typically go through when somebody passes away. In Illinois, it takes about 10 to 14 months on average to close out a probate. And the actual average in Illinois is about $18,000. But for most kind of mom and pop estates, I would say the average cost for a probate after all is said and done is about $7,500 to $10,000. Everything's not contested. We just have like one property, something along those lines. So first, we want to have an understanding that if no other estate planning is done, or if we're just relying on a will, that means we're okay with the probate system. We're okay about maintaining that property for 10 to 14 months until we can make the proper distributions and close out the probate. If we've got a trust, for example, that's an alternate process that we could take to the probate system. But we want to understand at least simply what probate is so that we can make the decision as to whether this is something that is appropriate for the estate to go through. Of course, down here, most of the time people want to avoid probate. That's pretty typical. So if that's the case, we can go back to our item number 2 up here, also reference our item number 7, and then in addition, our item number 5. So make sure that those beneficiary forms are set. There's no reason to have a 401k or any of the bank accounts or any bonds trigger a probate. Let's make sure that our bank accounts, retirement accounts, and our insurance, that mom and dad have all set beneficiaries or transfer on death designations on all of those accounts. And then, of course, from there, we can make the decision as to whether or not we want to, if we're not okay with probate, then we can have that conversation as to whether or not a trust is appropriate for this particular estate. And then we also want to give some thought to taxes. So in Illinois, there's no inheritance tax. However, there is a death tax. In order for the death tax to be an issue, your state would have to total over $4 million. So some of my clients do have that headache. It is a very nice headache to have. And if that's the case, I could have you guys come on in and we can go over death taxes. More commonly, though, the tax implication that I like to call people's attention to is the step up in basis in capital gains on real estate. So one thing that people will oftentimes do in a bid to avoid the probate system, but also in a bid to avoid paying to have a trust drafted, is what they'll do is they'll take the real estate that they have and they'll just add the kids onto it. So we'll have a deed that'll show mom, dad, and junior all on the same deed. So there's a couple problems that come with that. The first of those, of course, is that if there's ever a falling out or somebody changes their mind, you can't force those people to change. They have that 1/3 property interest, and you can't just take them off of the deed. The other issue that will come up is that if one of those added parties, if they end up going through a divorce or if they end up having creditor problems, now mom and dad's real estate is sucked into those legal actions. But as far as our tax concerns go, the big issue with taking that approach is that it does not preserve the step up in basis. So what that means is that we won't be minimizing the capital gains tax. If we have the property transferred either through a trust or through the probate court system, then this preserves the step up in basis. And because it preserves the step up in basis, we get to minimize capital gains tax. So I know I just threw a whole bunch of legalese at you. Let me kind of translate that. What we're discussing is what dates are we going to use to determine the increase in value of the property? Are we going to go with the original purchase date to the date of death when the property was transferred? Or are we going to go from the date of death to when it was sold? So if we're going from the date of death to the date that it was sold, then that's a very, very small period in which capital gains the value of the property can go up. Whereas if we have, say, a house that was purchased in 1956, and then mom and dad passed away, they both passed away in 2024, that's a huge period of time. And in that huge period of time, that property will have gained tremendously in value. You can kind of imagine how much property was worth in 1956 versus if that property was sold today. And that increase in valuation is what's going to be used to come up with a really, really big tax that most heirs do not want to pay. So if our goal is to minimize taxes, my recommendation is to talk with the attorney, and you're probably going to be either putting together a will or a trust, and we want to be avoiding that approach that sometimes people will take where they're just adding names onto deeds. And then, of course, there's general maintenance that we want to do. So sometimes mom and dad will have created a will. It might have been many, many years ago, and things will have changed. Sometimes the people on the will have passed away, or it might have predated back to when they had kids or before having kids. And we just want to look at those documents and make sure that everything is in order and that they were properly set up. So those are our 10 issues. If you have any questions about them, I would be happy to meet with you guys in person. You can just give me a call. My direct is 847 906-0005. And my email is anthony@nudo.net. I'd be happy to hear from you, and we can sit down and go over trusts, estates, and wills. My recommendation, though, if there is one big thing to take away from our discussion today, is plant that seed with mom and dad, get them to start thinking about it. Don't rush them. We want to keep in mind always the emotional experience of our loved ones, and just start that process of slowly bringing them in so that they can prepare those proper documents so that when they get sick, you can step in and do the appropriate things that you need to do to take care of them. So that's our presentation today. Hope you guys enjoyed it. Take care and have a great rest of the day.